Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm reviewing a book which has come to us from the Oxford University Press. They publish really first-class books which are of great assistance to us as practitioners and also for scholars involved in legal issues. This one is about international law as much as anything else, and of course arbitration. And it's published at a time, I think quite courageously, bearing in mind the problems we have internationally. The subject matter is international arbitration in Korea. It's been written by Joongi Kim, and the book review title we've given it, just so that it's clarified, is South Korea, the Next International Arbitration Hub? Find out more in this new O.U.P title. And I have to say that I was really intrigued when I saw this book. I thought, this is a book that looks really quite interesting. I know little about Korea. I'm also very worried about Korea because of the issues that we hear about internationally. So I thought it would be a book which was well worth looking at and reviewing. And that's in fact what we decided to do. Elizabeth and I wrote this. Elizabeth wrote the main review, and we did have a long chat about the what we're going to put in the review. There's the book anyway. There's the front cover. There's the spine. There's nothing on the back. It's a paper. It's not paper. It's a hardback. Nice blue cover. Runs to something like just under 500 pages. You can see the index. There's the back of the index there. Now, if you look, you can see that the index is actually by paragraph numbering. It's not by page numbering. And if we get into the book, which we will in a minute, I'll show you how it's structured. There's the front of the book anyway, the front page. Then we get into the detail from O.U.P. Then there's a nice dedication, which I shall just show you there, from the author. And then we get from there to a foreword. The foreword was very useful because it gave us some fairly substantial information for those of us who are not particularly familiar. A lot of useful information. It was written by Gary Bourne, the actual foreword. Then you've got a preface, of course, by the author as well, written in Seoul, from Seoul. And then you've got the contents itself. You can see the structure in parts and various other things. There's an historic overview. There's a lot of information here which I think is very helpful. There's an appendix at the back as well. There's a table of cases, and then after that you've got some legislation, and then after that you've got a very useful set of abbreviations. I've always found with any form of arbitration that they do tend to go for lots of abbreviations, and of course when you're dealing with international law, which is what this book does, it's bound to happen. So you've got to know the very basics. For instance, things like very basic abbreviations which are covered there, which I shall be mentioning actually in the review in a few minutes. Now there's the structure of the page. You see the chapter heading. There's a short index for each chapter, which basically tells you what's in it. Then you've got the paragraph numbering at the sides, and you have footnoting. You just go through and you can see how that's structured as the book runs through. There's the arbitral tribunal there, and you can see again the same sort of structure all the way through. A very interesting book, and as I say, a book which is quite relevant to our times, I think, bearing in mind what is happening. Now, what's the book about? Because this is what we say. Whenever there is commerce, there will inevitably be commercial disputes. This is no less true within the burgeoning economy of Korea. And this, of course, is South Korea, in case you were ever wondering. I say that because the word Korea is mentioned for a specific reason, and I don't want to go into any details because it may upset people. But although we're calling it Korea, for the purposes, this is South Korea that we are talking about. And I'm not referring in any way, shape or form to anything to do with North Korea, just so that is clarified in case anybody has any concerns. Because what I'm trying to do is to show where we are at the moment within international arbitration in that part of the world. The book's been authored by Joongi Kim, who's been writing it from Seoul. And it's a very readable and intriguing new title from O.U.P, which explores with scholarly thoroughness the development and the current realities of dispute resolution in a country that is no more basically than 50 or so years old. And it's raised itself from abject poverty to economic preeminence in a fiercely competitive global marketplace. And of course that I think goes without saying, because not too surprisingly, Korea has also become a key player in international arbitration, hence the pressing need for an authoritative legal text on the subject, and it's written in English of course, which has now been met with the publication of this book. It's not too difficult to predict that the book will be welcomed by the arbitration community worldwide. I certainly, because I don't do very much in this area, but I'm familiar with it, I've taught the subject as well, I'm very keen to make sure we have as much information as we can get. Now there's a quote here: "Korea's accelerated growth in arbitration remains intertwined with its economic development," says the author, adding that Korea has catapulted itself from one of the world's poorest countries to one of the world's largest creditors. And recall too the proliferation of South Korean brands such as Samsung, for example. Now, placing Korea's economic prowess firmly in an international context, the preface, the foreword rather, written by Gary Bourne, who was writing it in London, remarks that Asia has played a central role in a number of key developments in international arbitration, which he deems to be the preferred means of resolving cross-border commercial investment and other disputes. That's an interesting point, because I think as the century unfolds, we're going to get much more of this as we become much more global in our trade, in our activities, and all our commercial interests. It seems to be logical, unless something else happens, that's clearly what's going to be the way forward. Korean courts, Mr. Bourne goes on to say and explain, have rendered important decisions on the meaning of, for example, the New York Convention on the ICSID Convention, which is both ratified by South Korea, where the UN Citral model law has been adopted. And in international arbitration, these highly successful institutions are pivotal. And international lawyers as well as arbitrators will be all too familiar with these acronyms that I'm using. There is, as I say, the abbreviations list at the beginning, which does help. But if you don't fall into either category, you'll be reminded, for instance, that UN Citral is the United National Committee on International Trade Law, while the other is the International Centre for Settlement of Investment Disputes. Now, while on this subject, the book provides a list of abbreviations, which is very handy, not to mention tables of cases, legislation and arbitration, and for conscientious researchers, an extensive bibliography. The appendix contains the full text of Korea's 2016 Arbitration Act, translated by the author, who describes it as an unofficial translation, but it's very helpful. The final challenge for Korea, he concludes, will be whether it can become a bona fide hub of international arbitration on a par with Hong Kong and Singapore, and, one might add, London. Of course, London being at the moment a preeminent area, and one that we have to see the outcome of Brexit, but clearly that's very much a selling point for Britain in the future. Now, let me conclude by saying, can Korea attract arbitration cases that have no connection with it or with the region? Interesting question now. Judging from the contents of this book, it might appear that this dynamic and enterprising country, although continually under threat from what I can only describe as its malevolent northern neighbour, and I think that's a fair statement, it may well provide serious competition for other established centre of arbitration in the future. The reason being that the two Koreas have diametrically opposed views about everything, and we're talking about what we do within the society I'm practising in, and I'm not here to make a criticism basically of North Korea, which I'm not talking about because we're talking specifically about South Korea. The publication date, as I've indicated, is cited at 2017, and the book remains a work in progress, and that's exactly what it is. I think we're very fortunate to have a copy of it available to us. There it is again, International Arbitration in Korea by Joongi Kim, the spine, there's nothing on the back, and then what we've got in the book itself, just opening it up, arbitration procedure. I think it's important to bear in mind that, as I've indicated about the role in Singapore in particular, that it's useful to know about this particular area as well. See the structure of the book, you've got the index, you've got the paragraph numbering, and here you've got a case, which again is of quite useful importance. Then you've got some shaded areas which set out the detail of the case quite helpfully. You've got a lot of information, you've also got judgments as well, of course. All in all, a most interesting book, and I thought rather a find from O.U.P. So thank you very much to all concerned for an excellent subject, an excellent book on a subject which probably won't be of that much importance at the moment to people, but I think it will be of growing importance because, as the author says, it remains a work in progress. Thank you to all. Bye-bye.